Let's start with the differences between wills and trusts. I have a lot of clients who come to my office and they have a piece of paper and it's a will and they say, here's my will, this avoids probate, correct? But in actuality, all wills go through probate. Now, if you're married, probate would occur on the second of you and your spouse to die, as long as you jointly own everything together. So when I'm talking about the probate process, if you're not married, probate would occur when you've passed away on anything that you don't jointly own with someone else. But if you're married, the probate process would occur when the second of you and your spouse die, again, as long as you're joint on all of your assets. The probate process can be time-consuming. There are a lot of different forms required for probate, and there are certain deadlines on the forms that are required for probate. The probate process takes a minimum of 5 months, but typically a probate estate takes about 1.5 years before it's fully settled. And during this time period, that's when all the different documents are required by the probate court. The cost of probate is another concern of many people, and that really depends on the size of the estate. There's a filing fee as a minimum fee that the court charges, and they also charge what's called an inventory fee, which is based on the size of your estate. And once the estate is probated, once the fees are paid to the court, if an attorney is hired to help with the probate estate, then that adds an additional cost onto probate. And there are some other miscellaneous fees also involved with probate. So probate can become costly, again, depending on the size of the estate. The other thing about probate is everything's public. When a probate estate is opened with the probate court, everything is a public record. So anybody at any time can find out anything about your estate that they want to find out. A lot of people don't like that. A lot of my clients are private and they want to make sure their information stays private. So those are some of the concerns that many people have about having a will done and that goes through probate. A will is better than nothing at all. However, if you want to avoid the probate process, the best thing to do is to set up a living trust. What happens with a living trust is a 2-step process. So if you already have a living trust, you have to make sure the second step is followed. The first step is you actually set up the trust documents themselves. In those documents, you get to say who your beneficiaries are. Those are the people or charities or churches that would inherit your estate. You get to say who your successor trustee is, and that's the person who administers your estate. And you can get creative with minor children. You can set up trusts for them that they wouldn't get until they reached a later age. You can make sure college is paid for. Lots of different things can be considered when you're setting up a living trust. That's the first step then. There are a few documents involved with a trust that work together to make sure that the estate is administered smoothly and avoids probate. The second step is very important. That step is called funding your trust. And what that means is any asset that you own that does not have a beneficiary has to be retitled into the name of your trust to avoid probate. So any beneficiary assets, that would go to the beneficiary. Any non-beneficiary asset would have to be retitled into the trust to avoid probate. For example, the deed to your home would have to be retitled or redeeded into the name of your trust. So if it's the Jones Trust and you own that property, it would still be in your name as trustee of the Jones Trust. You still control everything while you're alive as long as it's a revocable living trust. But what happens is by doing this retitling, the assets then become immediately in the control of your successor trustee. So they step right into your shoes on all of your assets that are retitled into the name of your trust. That's the key to avoiding probate. So trusts can be fully administered within a couple of months, depending on, of course, on how quickly your successor trustee gets into action on doing their duties. But it's a smoother process. It's a private process because the court is not involved. Only the beneficiaries of your trust receive copies of all your trust information. So that's why people like a living trust. It avoids the probate process. It avoids the costs of going through probate. And quite simply, it's just easier on your surviving family members to administer your estate. They get it done quicker and easier. And I have so many of my clients that come in and say, this was so easy. What did I miss? My mom or dad has just passed away, or brother or sister. What did I miss? They had a trust. I feel like I've missed something, and they haven't. They have it done correctly, and they have it done a lot easier. So if that's of interest to you, you can explore that more. A lot of institutions have seminars on living trusts. I do a lot of seminars on living trusts. You can simply contact my office and find out when another seminar date is. Thank you.